You just opened your mail and received a notice of hearing from the Office of State Administrative Hearings. You may have never heard of our office and may wonder what this is. The Office of State Administrative Hearings, commonly referred to as OSAH, resolves disputes between the public and state agencies. You have disagreed with a state agency's decision. It is OSAH's job to provide a hearing to review the state agency's decision. As an independent entity, OSAH provides assurance to Georgians that state agencies act in accordance with approved laws, rules, and regulations. So what do you do now? Well, you've taken the first step by watching this video. It is our hope that this video will help you to better understand the hearing process. An administrative law judge will decide your case. The role of the administrative law judge is to listen to the evidence presented by both sides. The case will be decided based on the evidence presented at the hearing. The judges are fair and impartial and do not represent either side. This video contains tips on how to prepare and present your case. These are general guidelines. OSAH judges conduct hearings throughout the state on a variety of subjects. Hearings take place in large courtrooms, small courtrooms, conference rooms, and other locations. Audio tape recordings are made of most hearings. At times, a court reporter assists the judge in recording the testimony. It is important that you read the notice of hearing carefully. The notice of hearing contains the time and location of your hearing. It is important that you arrive on time for your hearing. You will notice that there may be a number of other people waiting for their hearing when you arrive. Usually, similar cases are scheduled for the same time. But each case will be heard individually, and you have the option of having your hearing held in private. If you prefer a private hearing, speak to the judge. Many times, a discussion between the parties can resolve the matter and avoid the need for the hearing. This conversation can take place prior to your hearing. If the case is resolved, you should inform the judge. If the case is not resolved, the hearing will proceed and each party will have an opportunity to present his or her case. The judge will decide who will present evidence first. The hearing provides you with an opportunity to explain your case. You should bring any evidence that may be helpful to your case. This may include documents such as receipts or bills. It may also be helpful to bring any notes you have about the case. It is only natural to be nervous in these unfamiliar surroundings, but the judge will ensure that the process is as non-threatening as possible and will answer all of your questions about the case. Okay, let's begin. What you're about to see are examples that illustrate various stages of a hearing. Throughout this video, we will provide you with information about the stages of the hearing you are viewing. At the beginning of your case, the judge may ask you to make an opening statement. This is not evidence, but a brief statement to the judge explaining what you expect the evidence will prove.
Your Honor, the evidence that I will present today will show that on at least 2 occasions, I asked the petitioner to present me with income verification, which is necessary to process her food stamp application. She failed to provide it, so her application was denied.
Your Honor, I expect the evidence to show that I wanted to give him the information, but I couldn't get it from my ex-husband. And also I expect to prove that I couldn't make it to the second appointment because I was sick.
Now that was a good example of how to make an effective opening statement. The parties provided a short statement that helped the judge understand the case. After opening statements, you will have the opportunity to present your evidence to the judge. Often there are no witnesses other than yourself, and you simply tell the judge what happened and what it is that you want him or her to know that proves your case. If you do have a witness, you will begin by asking questions of your witness. You should come prepared and already know what you expect them to say. Your questions should help the witness tell what happened without telling them the answer. One of the most important things to remember is not to interrupt a witness when they are talking. The following is an example of a leading question that is inappropriate because the question tells the witness what answer to give.
Wasn't I homesick with the flu on June 1st, 2004?
A better way to get the answer might be like this.
Do you know where I was on June 1st, 2004?
The other party has an opportunity to question or cross-examine each witness. You will have an opportunity to testify, so it is important that you ask questions, not testify. If you want to ask a question but don't know how, ask the judge to assist you in phrasing your question. Some judges will ask their own questions, while other judges rely on the party to ask all of the necessary questions. It is very important to think about the questions that you want to ask. Make notes to yourself on the topics that you think are relevant to your case. Remember, you should never interrupt a witness when he or she is answering a question. What you're about to see is an example of a party telling the story of what happened rather than asking a question. You will see the judge helping the party ask the witness questions.
When I came to the office to meet with you, you told me I only needed to bring my paycheck stubs. Don't you remember I told you I would bring them as soon as I could, but I have 2 small kids and I'm working all the time.
I know you have a lot you want to tell me, but this is your opportunity to ask questions. You will have the chance a little later to testify if you want to. At this time, do you have any questions you want to ask Ms. Johnson?
Yes, I do. Don't you remember telling me all I had to do was bring my paycheck stubs?
Yes, I did.
And didn't I tell you I have 2 small kids and I work all the time?
Yes, you did.
You may have a document that has information about your case. Be sure that you bring it to the hearing along with at least 2 copies. The agency representative will receive 1 copy and the other copy will be given to the judge. Written statements from friends are not permitted. Instead, you should bring the friend with you to the hearing. If you have documents that contain information about your case, such as a medical bill, pay stubs, or a copy of a letter that you wrote to the agency, bring it with you to the hearing. You should number each document prior to the hearing.
I'd like you to look at this document that's been marked Exhibit 1. Now, Ms. Johnson, can you tell me what this document is?
It looks like the verification checklist I gave you during your initial interview on September 30th.
I'd like this document to be made part of the record.
Ms. Johnson, do you have any objections to Exhibit 1?
No.
All right, Exhibit 1 is entered into the record at this time.
The other side might have documents that they want to introduce into evidence. You have 2 very important rights at this stage of the hearing. First, you have the right to examine the documents. Second, you have the right to request that the documents be kept out of the record of the case. This is referred to as filing an objection to the exhibit. You should be prepared to tell the judge why the document should not be made part of the record of the case. The following scene gives an example of how someone might object to a letter that an agency is attempting to place into evidence.
Your Honor, at this point we would like to introduce a letter that we received from the petitioner's landlord on July 3rd, 2004.
Please number the exhibit as Exhibit Number 2. Have you shown the petitioner the letter?
No, Your Honor, we did not know that was necessary.
It is necessary. Please show the letter to the petitioner. Petitioner, Could you please let me know when you have completed examining the letter?
Your Honor, I've completed examining the letter.
And do you have any objections to my accepting that letter into the evidence?
Yes, Your Honor, I do object to this letter because it contains some lies about my family, and the landlord is not present to be questioned about these lies.
Is there a response from the other side?
Yes, the landlord would not agree to be here today, Your Honor, and we felt you needed that information that's in the letter.
I agree with the objection. This letter contains what the law calls hearsay evidence, and such evidence is generally not admissible.
You should note that the agency representative was unsuccessful in entering this document into evidence. Usually, written statements from a witness who does not attend the hearing will not be accepted into evidence. It is extremely important that you have your witnesses appear at the hearing, and you have the right to request subpoenas to require witnesses to appear. The judge's case management assistant can help you obtain subpoenas. After the evidence is presented, the judge will ask the parties to make closing arguments. This is your opportunity to tell the judge why the case should be decided in your favor. You should not bring in new evidence at this stage. The following scene is an example of closing arguments in a food stamp case. In this case, the agency denied the petitioner's application because he did not give her case manager a light bill.
Does the agency have a closing argument?
Yes, we do. The food stamp manual states that in order for a food stamp application to be approved, the applicant must provide the agency with the necessary documents. However, through this hearing, we have proven that he failed to provide us with a most recent light bill statement. Therefore, we were correct in denying his application for food stamps.
Does the petitioner wish to make a closing argument?
Yes. I think that it was wrong for the DFCS to deny my application based on the evidence that I presented here today. I did everything I could to cooperate with my caseworker except provide a copy of my most recent light bill, which I misplaced. Therefore, I think that they should approve my application.
Closing arguments are the final stage in a hearing. The judge will not issue a decision on your case on the day of the hearing. Once a decision is rendered, you will be notified by mail. Included in this information will be an explanation of your rights should you disagree with the decision. Thank you for your interest in the OSAH hearing process. If you have further questions about your hearing, ask the judge assigned to your case.